Convention Number 138 concerning minimum age for admission to employment, done at Geneva on the 26th of June 1973, entry into force, the 19th of June 1976. Preamble. The General Conference of the International Labour Organization, having been convened at Geneva by the governing body of the International Labour Office, and having met in its 58th session on the 6th of June 1973, and having decided upon the adoption of certain proposals with regard to minimum age for admission to employment, which is the fourth item on the agenda of the session, and noting the terms of the Minimum Age, Industry, Convention, 1919, the Minimum Age, Sea, Convention, 1920, the Minimum Age, Agriculture, Convention, 1921, the Minimum Age, Trimmers and Stokers, Convention, 1921, the Minimum Age, Non-Industrial Employment, Convention, 1932, the Minimum Age, Sea, Convention, Revised, 1936, the Minimum Age, Industry, Convention, Revised, 1937, the Minimum Age, Non-Industrial Employment, Convention, Revised, 1937, the Minimum Age, Fishermen, Convention, 1959, and the Minimum Age, Underground Work, Convention, 1965, and considering that the time has come to establish a general instrument on the subject, which would gradually replace the existing ones applicable to limited economic sectors, with a view to achieving the total abolition of child labor, and having determined that these proposals shall take the form of an international convention, adopts this 26th day of June of the year 1973 the following convention, which may be cited as the Minimum Age Convention, 1973, Article 1, each member for which this convention is in force undertakes to pursue a national policy designed to ensure the effective abolition of child labor and to raise progressively the minimum age for admission to employment or work to a level consistent with the fullest physical and mental development of young persons. Article 2, 1. Each member which ratifies this convention shall specify, in a declaration appended to its ratification, a minimum age for admission to employment or work within its territory and on means of transport registered in its territory, subject to Articles 4 to 8 of this convention. No one under that age shall be admitted to employment or work in any occupation. 2. Each member which has ratified this convention may subsequently notify the Director General of the International Labour Office, by further declarations, that it specifies a minimum age higher than that previously specified. 3. The minimum age specified in pursuance of paragraph 1 of this article shall not be less than the age of completion of compulsory schooling and, in any case, shall not be less than 15 years. 4. Notwithstanding the provisions of paragraph 3 of this article, a member whose economy and educational facilities are insufficiently developed may, after consultation with the organizations of employers and workers concerned, where such exist, initially specify a minimum age of 14 years. 5. Each member which has specified a minimum age of 14 years in pursuance of the provisions of the preceding paragraph shall include in its reports on the application of this convention submitted under Article 22 of the Constitution of the International Labour Organization a statement, a, that its reason for doing so subsists, or, b, that it renounces its right to avail itself of the provisions in question as from a stated date. Article 3, 1. The minimum age for admission to any type of employment or work which by its nature or the circumstances in which it is carried out is likely to jeopardize the health, safety or morals of young persons shall not be less than 18 years. 2. The types of employment or work to which paragraph 1 of this article applies shall be determined by national laws or regulations or by the competent authority, after consultation with the organizations of employers and workers concerned, where such exist. 3. Notwithstanding the provisions of paragraph 1 of this article, national laws or regulations or the competent authority may, after consultation with the organizations of employers and workers concerned, where such exist, authorize employment or workers from the age of 16 years on condition that the health, safety and morals of the young persons concerned are fully protected and that the young persons have received adequate specific instruction or vocational training in the relevant branch of activity. Article 4, 1. Insofar as necessary, the competent authority, after consultation with the organizations of employers and workers concerned, where such exist, may exclude from the application of this convention limited categories of employment or work in respect of which special and substantial problems of application arise. 2. Each member which ratifies this convention shall list in its first report on the application of the convention submitted under Article 22 of the Constitution of the International Labour Organization any categories which may have been excluded in pursuance of paragraph 1 of this article, giving the reasons for such exclusion, and shall state in subsequent reports the position of its law and practice in respect of the categories excluded and the extent to which effect has been given or is proposed to be given to the convention in respect of such categories. 3. Employment or work covered by Article 3 of this convention shall not be excluded from the application of the convention in pursuance of this article. Article 5, 1. A member whose economy and administrative facilities are insufficiently developed may, after consultation with the organizations of employers and workers concerned, where such exist, initially limit the scope of application of this convention. 2. Each member which avails itself of the provisions of paragraph 1 of this article shall specify, in a declaration appended to its ratification, the branches of economic activity or types of undertakings to which it will apply the provisions of the Convention. 3. The provisions of the Convention shall be applicable as a minimum to the following: mining and quarrying, manufacturing, construction, electricity, gas and water, sanitary services, transport, storage and communication, and plantations and other agricultural undertakings mainly producing for commercial purposes, but excluding family and small-scale holdings producing for local consumption and not regularly employing hired workers. 4. Any member which has limited the scope of application of this convention in pursuance of this article, a. shall indicate in its reports under Article 22 of the Constitution of the International Labour Organization the general position as regards the employment or work of young persons and children in the branches of activity which are excluded from the scope of application of this convention and any progress which may have been made towards wider application of the provisions of the convention. b. May at any time formally extend the scope of application by a declaration addressed to the Director General of the International Labour Office. Article 6. This convention does not apply to work done by children and young persons in schools for general, vocational or technical education or in other training institutions, or to work done by persons at least 14 years of age in undertakings, where such work is carried out in accordance with conditions prescribed by the competent authority, after consultation with the organizations of employers and workers concerned, where such exist, and is an integral part of, a course of education or training for which a school or training institution is primarily responsible. b. A program of training mainly or entirely in an undertaking, which program has been approved by the competent authority. Or, c. A program of guidance or orientation designed to facilitate the choice of an occupation or of a line of training. Article 7, 1. National laws or regulations may permit the employment or work of persons 13 to 15 years of age on light work which is, a. not likely to be harmful to their health or development, and, b. not such as to prejudice their attendance at school, their participation in vocational orientation or training programs approved by the competent authority or their capacity to benefit from the instruction received. 2. National laws or regulations may also permit the employment or work of persons who are at least 15 years of age but have not yet completed their compulsory schooling on work which meets the requirements set forth in subparagraphs A and B of paragraph 1 of this article. 3. The competent authority shall determine the activities in which employment or work may be permitted under paragraphs 1 and 2 of this article and shall prescribe the number of hours during which and the conditions in which such employment or work may be undertaken. 4. Notwithstanding the provisions of paragraphs 1 and 2 of this article, a member which has availed itself of the provisions of paragraph 4 of Article the 2nd of May, for as long as it continues to do so, substitute the ages 12 and 14 for the ages 13 and 15 in paragraph 1 and the age 14 for the age 15 in paragraph 2 of this article. Article 8, 1. After consultation with the organizations of employers and workers concerned, where such exist, the competent authority may, by permits granted in individual cases, allow exceptions to the prohibition of employment or work provided for in Article 2 of this Convention, for such purposes as participation in artistic performances. 2. Permits so granted shall limit the number of hours during which and prescribe the conditions in which employment or work is allowed. Article 9, 1. All necessary measures, including the provision of appropriate penalties, shall be taken by the competent authority to ensure the effective enforcement of the provisions of this Convention. 2. National laws or regulations or the competent authority shall define the persons responsible for compliance with the provisions giving effect to the Convention. 3. National laws or regulations or the competent authority shall prescribe the registers or other documents which shall be kept and made available by the employer. Such registers or documents shall contain the names and ages or dates of birth, duly certified wherever possible, of persons whom he employs or who work for him and who are less than 18 years of age. Article 10, 1. This Convention revises, on the terms set forth in this article, the minimum age, Industry, Convention, 1919, the minimum age, Sea, Convention, 1920, the minimum age, Agriculture, Convention, 1921, the minimum age, Trimmers and Stokers, Convention, 1921, the minimum age, Non-Industrial Employment, Convention, 1932, the minimum age, Sea, Convention, revised, 1936, the minimum age, Industry, Convention, revised, 1937, the minimum age, Non-Industrial Employment, Convention, revised, 1937, the minimum age, Fishermen, Convention, 1959, and the minimum age, Underground Work, Convention, 1965. 2. The coming into force of this Convention shall not close the minimum age, Sea, Convention, revised, 1936, the minimum age, Industry, Convention, revised, 1937, the minimum age, Non-Industrial Employment, Convention, revised, 1937, the minimum age, Fishermen, Convention, 1959, or the minimum age, Underground Work, Convention, 1965, to further ratification. 3. The minimum age, Industry, Convention, 1919, the minimum age, Sea, Convention, 1920, the minimum age, Agriculture, Convention, 1921, and the minimum age, Trimmers and Stokers, Convention, 1921, shall be closed to further ratification when all the parties thereto have consented to such closing by ratification of this Convention or by declaration communicated to the Director General of the International Labour Office. 4. When the obligations of this Convention are accepted, a. by a member which is a party to the minimum age, Industry, Convention, revised, 1937, and a minimum age of not less than 15 years is specified in pursuance of Article 2 of this Convention. This shall ipso jure involve the immediate denunciation of that Convention, b. in respect of non-industrial employment as defined in the minimum age, non-industrial employment, Convention, 1932, by a member which is a party to that Convention. This shall ipso jure involve the immediate denunciation of that Convention, c. in respect of non-industrial employment as defined in the minimum age, non-industrial employment, Convention, revised, 1937, by a member which is a party to that Convention. and a minimum age of not less than 15 years is specified in pursuance of Article 2 of this convention. This shall ipso jure involve the immediate denunciation of that convention. D. In respect of maritime employment, by a member which is a party to the minimum age, c. Convention. Revised, 1936, and a minimum age of not less than 15 years is specified in pursuance of Article 2 of this convention, or the member specifies that Article 3 of this convention applies to maritime employment. This shall ipso jure involve the immediate denunciation of that convention. E. In respect of employment in maritime fishing, by a member which is a party to the minimum age, fisherman, Convention, 1959, and a minimum age of not less than 15 years is specified in pursuance of Article 2 of this convention, or the member specifies that Article 3 of this convention applies to employment in maritime fishing. This shall ipso jure involve the immediate denunciation of that convention. F. By a member which is a party to the minimum age, underground work, Convention, 1965, and a minimum age of not less than the age specified in pursuance of that convention is specified in pursuance of Article 2 of this convention, or the member specifies that such an age applies to employment underground in mines in virtue of Article 3 of this convention. This shall ipso jure involve the immediate denunciation of that convention, if and when this convention shall have come into force. 5. Acceptance of the obligations of this convention, a. shall involve the denunciation of the minimum age, industry, Convention, 1919, in accordance with Article 12 thereof. B. In respect of agriculture shall involve the denunciation of the minimum age, agriculture, Convention, 1921, in accordance with Article 9 thereof. C. In respect of maritime employment shall involve the denunciation of the minimum age, c. Convention, 1920, in accordance with Article 10 thereof, and of the minimum age, trimmers and stokers, Convention, 1921, in accordance with Article 12 thereof, if and when this convention shall have come into force. Article 11. The formal ratifications of this convention shall be communicated to the Director General of the International Labour Office for registration. Article 12. 1. This convention shall be binding only upon those members of the International Labour Organization whose ratifications have been registered with the Director General. 2. It shall come into force 12 months after the date on which the ratifications of 2 members have been registered with the Director General. 3. Thereafter, this convention shall come into force for any member 12 months after the date on which its ratifications has been registered. Article 13. 1. A member which has ratified this convention may denounce it after the expiration of 10 years from the date on which the convention first comes into force, by an act communicated to the Director General of the International Labour Office for registration. Such denunciation shall not take effect until 1 year after the date on which it is registered. 2. Each member which has ratified this convention and which does not, within the year following the expiration of the period of 10 years mentioned in the preceding paragraph, exercise the right of denunciation provided for in this article, will be bound for another period of 10 years and, thereafter, may denounce this convention at the expiration of each period of 10 years under the terms provided for in this article. Article 14. 1. The Director General of the International Labour Office shall notify all members of the International Labour Organization of the registration of all ratifications and denunciations communicated to him by the members of the organization. 2. When notifying the members of the organization of the registration of the second ratification communicated to him, the Director General shall draw the attention of the members of the organization to the date upon which the convention will come into force. Article 15. The Director General of the International Labour Office shall communicate to the Secretary General of the United Nations for registration in accordance with Article 102 of the Charter of the United Nations full particulars of all ratifications and acts of denunciation registered by him in accordance with the provisions of the preceding articles. Article 16. At such times as it may consider necessary, the governing body of the International Labour Office shall present to the General Conference a report on the working of this convention and shall examine the desirability of placing on the agenda of the conference the question of its revision in whole or in part. Article 17, 1. Should the conference adopt a new convention revising this convention in whole or in part, then, unless the new convention otherwise provides, a. the ratification by a member of the new revising convention shall ipso jure involve the immediate denunciation of this convention, notwithstanding the provisions of Article 13 above, if and when the new revising convention shall have come into force. B. As from the date when the new revising convention comes into force, this convention shall cease to be open to ratification by the members. 2. This convention shall in any case remain in force in its actual form and content for those members which have ratified it but have not ratified their revising convention. Article 18. The English and French versions of the text of this convention are equally authoritative.